You're tuned in to The Andrew Lawton Show.
Before I introduce my next guest, I want you to take a look at this video clip from one of these very star chambers.
And I always, in an investigation interview, I always ask people, even though they've been as thorough as you have, in summary fashion, what was your intent and purpose of your article with the cartoon illustrations published on February 27, 2006?
Why is that a relevant question?
Under section 3(1)(a), it talks about intention, purpose. We like to get some background as well.
Is it you'd like to get some background, or does this determine anything? If we published what we published, the words in the picture speak for themselves. Are you saying that one answer is wrong and one answer is right? Will a certain answer contrary to law?
No.
So if I were to say, hypothetically, that the purpose was to instill hatred, incite hatred, and cause offense, are you saying that's an acceptable answer?
I have to look at it in the context of all the information and determine if it was indeed.
I think you're playing silly butter here. I think you know that the answer here, that answer would be illegal.
Anything is possible, I guess, but again, I look at it, this kind of Section 3 case takes a lot of analysis, so there's a lot of things I have to look at. That piece of information is just one.
My answer to your question is as follows. We published those cartoons for the intention and purpose of exercising our inalienable rights as free-born Albertans to publish whatever the hell we want, no matter what the hell you think.
That was, of course, our friend Ezra Levant being grilled by an investigator with the Alberta Human Rights Commission, Charlene McGovern, as to what his intent was in choosing to publish, at the time in the Western Standard, the infamous Danish Muhammad cartoons, because this is exactly what human rights regulations and regimes do when they start tackling free speech, delving into your thinking behind doing certain things, which all should be protected under free speech. Fast forward to 13 years, we have Ezra Levant, rebel commander himself and great friend of this show, with us. Ezra, good to talk to you. Thanks for coming on today.
Well, it's my pleasure. I'm afraid the law under which I was prosecuted over a dozen years ago, it's coming back through the liberal bill C-36, and actually it's coming back sort of weaponized. You know those killer bees, and then there's Africanized killer bees that are even tougher, apparently. This isn't just like Section 13 I was grilled under. This is like a killer bee version of that is much worse, and I'm happy to tell you why.
Yeah, and I want to talk first off, because a lot of people have looked at this and said, okay, well, you know, Mark Steyn and Maclean's were prosecuted under the BC Human Rights Tribunal. You were taken to task by Alberta, and this is, of course, the Canadian Human Rights Commission that will have these new powers. But my position on this has always been that, first off, the provinces tend to follow the lead of the federal government, but also they're all part of this one major regime, which is a regime that decides the speech that is uttered by individual people, by media platforms, now by bloggers and people on social media. It's all part of the same overarching discourse.
Yeah. Well, I'm afraid that the pendulum is swinging against free speech. I think the pendulum swung towards free speech because of the overreach by the Alberta Human Rights Commission in the video you showed there, and their attack on Mark Steyn. But that was that was about a decade ago. And since that time, cancel culture, woke racial identity politics have become mainstream. They've leaped out of the fringes of academia into the courts and certainly into politics. And so it's coming back, and it will be used vigorously. And they've added some accelerant to it. Let me give you two examples. That video you just showed, I was filming, that was actually at my law firm's office. We had the right to film that interrogation, to talk about the accuser against me, who was a radical imam born in Pakistan, came to Canada, didn't accept our ideas of the separation of mosque and state, etc. That would be impossible under the new rule. Because under Bill C-36, the Human Rights Commission has the right to ban anyone from knowing who the accuser is, who the complainant is. So not only would I not be able to know, but no one else in the media, in the public would be able to know. We have secret complainants and now secret witnesses. Those are explicitly outlined in Bill C-36. So it's not just the same censorship as before. It's the same censorship, but they want to ensure that no one will ever be able to fight back. You'll never know who's coming for you, whether it's, I don't know, a disgruntled ex-employee, a disgruntled ex-wife or ex-husband or ex-boyfriend or ex-girlfriend, a rival, or I think the most likely scenario in Canada, one of the Liberal government's paid aggressor groups like the laughably named Canadian Anti-Hate Network. They just got a $250,000 grant from Stephen Guilbeault to go out and hunt and complain against conservative opponents of Justin Trudeau. They literally got a $250,000 budget to hunt down Trudeau's enemies online and complain against them. Well, who do you think is going to be the number one customer of this hate speech provision? But we'll never know.
This is tremendously important, though, because this body, the Canadian Human Rights Commission, is not like a crown attorney. It's not supposed to have an independent prosecution arm. But when Section 13 was around the first time, almost all of the complaints were filed by one single person. And we just know that there will be activists whose full-time job is finding this Twitter account they don't like, this episode of your show, of my show, and just filing in a systematic way these complaints.
Well, yeah, and I forgot to mention, not only can the complainant be a group or a corporation that's kept secret, and not only can they give evidence in secret, and by the way, we don't do that for any other kind of law. You can be prosecuting the mafia, and you still have to take a stand, say your name, because we have to know, well, is it a grudge from a rival mob boss?
Yeah, I think I learned that in grade 11, that the right to face your accuser is one of the cornerstones of the rule of law in Canada.
Yeah, otherwise, how do you know what the angle is? How do you know what the grudge is? So not only are you allowed to be a secret complainant and give secret evidence, but you get $20,000 a pop every time you catch someone. And under C-36, not only do you get up to 20 grand, but the person who made the offensive Facebook post has to also pay the government 50 grand. So
I missed this. You're saying you can actually claim a bounty if you haul someone before the commission and win.
Yeah, it's right there in the legislation, up to $20,000 per case. So that's a really profitable business. And I think that's tax-free. You go to the Human Rights Commission in secret. You don't have to hire a lawyer. They do it for you. The bad guy is put on trial. You can give secret evidence. Obviously, you're not going to be cross-examined on it in any meaningful way if you're secret. And if you win, you get $20,000. Well, why wouldn't people make a living out of this? This is creating a whole new industry. But I have to tell you, Andrew, what we've been talking about isn't even the worst part of the bill. It's terrible, but it is nowhere near the worst part of the bill. This bill, C-36, does bring back the censorship provision. It does reintroduce the counterfeit right not to be offended. It has all of that in there. The pre-crime, like you publish something likely to cause hurt feelings. All that's back, and the new secrecy provisions in there, and the $20,000 bounty, it's in there. Check for yourself, it's all in the bill. That's not the worst part, Andrew. The worst part is they also, in the same bill, make changes to the criminal code, changes I've never seen or heard of anywhere in the free world, and I can explain them to you in 2 minutes. The criminal code, so I'm not talking about some kangaroo court, Human Rights Commission. The criminal code is being amended in this same bill to allow anyone in Canada to go to a provincial court and apply for what they call a recognizance. It's like bail. Apply to get their enemy, their political rival, to have a bunch of conditions put on their life. It's like a restraining order, but it only applies for bias crimes and hate crimes. You can't get this restraining order if someone is a robber or a murderer or a rapist or any of those things. It's a special criminal code provision only for bias crimes, but get this, you can get it for someone who hasn't done anything yet. They haven't done anything yet.
This is the Minority Report peace bond for a crime that someone may commit in the future.
In fact, the title of this is fear of a hate crime. So you go to court and say, Your Honor, he hasn't done anything. He's not accused, he's not charged, he's not convicted, he's not tried, he's not sentenced. He's not a criminal, Your Honor. But this new section of the criminal code says if I'm afraid of him, only for hate, that human emotion, not for he's going to kill me, he's going to rape me, he's going to stab me, he's going to rob me. No. I'm afraid that he's a hater. You can get a judge to give you a list of things that would shock you, Andrew. Let me tell you some of them. You can get someone put under house arrest. You can limit the places they go if they're allowed out for certain hours of the day. You can ban them from any place, whether it's their work, school, business, family. You can ban them from communicating directly or indirectly with any person. Again, family, friends, political party, associates, employees. You can get any firearms they own legally seized. You can ban them, this is crazy, from drinking wine, beer, or any other alcohol.
And subject them to testing of that, it looked like.
Oh, yeah. Well, and they have to take a blood, urine, or DNA test on command. The no communication part is insane. The no meeting people, no going places is insane. And an electronic ankle monitor, like you would put on a sexual predator or something. You can't go to court, Andrew, and say, I'm afraid of that sexual predator, put an ankle monitor on him. Because the courts would say, that's a pre-crime, he hasn't done it yet. When he's done something, we'll arrest him. You can't say, that man, I think he's going to kill me. The judge would say, he hasn't done it yet. We'll stop him if he moves on you, but only for these new hate crimes under C-36. Hate's a human emotion, by the way. You can go to court and get a preemptive strike against your political enemies for all these things we lined out: ankle monitor, no alcohol, blood, urine, and DNA testing, no firearms, no leaving the house during certain hours, no going to certain places, no communicating directly or indirectly with certain people. I've never heard of that before. That's a pre-crime like Minority Report. And I've never heard of anything so illiberal. If that bill becomes law, I truly think we will live in I'm not going to say an unfree country, but I'll say just a partially free country if that becomes law.
And just while we're talking about the peace bond here, I want to read, if I can. This is under the bill, section 810.012, subsection 5. If you refuse to enter into this recognizance, you can be put in jail by the provincial judge for 12 months.
Yeah.
So if the judge says, yes, we think that person X is right to fear you may commit one of these new hate offenses, and you say, I'm not playing ball, you can be put in jail for that alone for 12 months. And you are right. I mean, I talked to Christine Van Gyn of the Canadian Constitution Foundation about this last week, and she said peace bonds are already subjected to a lot of criticism from civil libertarians because of the nature of them going for future crimes that you've not been charged or convicted of, and to apply that to something that involves a level of thinking, a thought crime, is absolutely egregious.
Yeah, I mean, I remember when I was an articling student way back in the day, one of the very first things I did was to serve a restraining order on a bad guy to keep away from his ex. And I remember drafting that, and it was a very powerful legal tool, and I served him on him. He was actually in jail. I went into the maximum security jail to serve him with this restraining order, which just sounds weird, but he was going to get out, and his ex was afraid. Even in that restraining order against a convicted criminal, he still had rights. At the bottom of the restraining order, it basically said, if you disagree with this, come back to court and say why, and it might be modified. But the bar was high to get that. And to have a political restraining order, if you are afraid someone has the human emotion of hate, not that they're going to hurt you. Let me just be crystal clear. Another thing Bill C-36 does is it defines hate as an emotion, which is true. So you're criminalizing an emotion and criminalizing it, because if someone's afraid you're going to have an emotion and commit an emotion crime, they can go to a court. Now, I should note that the Attorney General has to sign off on that, but these days, what Attorney General wouldn't? So...
Well, yeah, and by the way, just on an aside, we know what happens when attorneys general defy the political will of the governments they serve. Just ask Jody Wilson-Raybould. So there is no protection about this process not becoming politicized on both the Human Rights Act complaints and also this peace bond power.
Yeah, and it's terrifying. And I have to tell you, I was thinking about myself when I read this, and I, not out of vanity, I just thought, who do they have in mind? Who in this country would they try and shut down, say you can't talk to your employees, you can't talk to the public, you can't go places, I think that they have clearly in mind, I mean, they've come for me before, you just showed a clip of it. Of course they're going to talk about Rebel News. I think they might come for TNC.news also. I think they might even go for Maxime Bernier. They've already arrested him for going to a peaceful political protest in Manitoba. I think this is absolutely 100% about shrinking the bandwidth of political dissent in this country. It's got nothing to do with real crime. Let me give you this example, Andrew. In the last week, 5 Catholic churches have been burnt by arson. That's a real crime. Destruction of property, destruction of the religious center of so many of these communities. Not even a statement from Justin Trudeau. You've got a crime wave. You might even call it a terrorist crime wave. It's certainly a hate crime wave. Real life, not a peep from Trudeau. And frankly, Aaron O'Toole's been pretty quiet too.
Well, and I've talked earlier on about Aaron O'Toole's silence on C-36. Let me just ask you before we wrap things up here, Ezra, you literally wrote the book more than a decade ago about this. It was a great book, Shakedown, How Our Government is Undermining Democracy in the Name of Human Rights. In 2013, you saw the repeal of Section 13, and this was a victory for people who like free speech. Did you envision it coming back at that point? Did you think that it was going to be a short-lived victory?
Well, I was worried because when that bill passed to repeal the censorship provision, only a single non-conservative MP voted for it. Scott Sims, the Liberal who's still an MP. The Bloc, all the other Liberals, the NDP voted for censorship. So I knew that it was time limited because those parties don't believe in freedom of speech anymore. And we see that now. My worry is that the Conservatives don't believe in free speech either. I'm worried that our judges don't believe in free speech either. I'm worried that our civil liberties NGOs don't believe in free speech, at least for certain people. And we've seen that through the lockdown and the shrinking of our civil liberties over the last year and a half. I am worried not just that the liberals mean it, but that most of society does too. And it's a shame because, and the media, by the way, when I was charged with hate speech a decade ago, 90% of the media, including most of the CBC, were supportive of me. These days, they would be cheering a prosecution. So I hate to say it, but the cultural leadership of Canada, the political leadership, the legal leadership, the academic leadership, it's completely for cancel culture. This bill, Bill C-36, is the legislation of cancel culture. And the only people against it are the people. I don't know if that's enough. All the establishment is for it. I know ordinary Canadians are against it, or at least I hope so. Maybe they've been infected with wokeism too, Andrew.
I wish I could have brought you on to be the bringer of better news, but you know what? People need to understand how bad things are to understand the stakes in fighting back. Ezra Levant, Rebel Commander, and even though it's 12 years old, I have to promote that book again, author of Shakedown, How Our Government is Undermining Democracy in the Name of Human Rights. Buy it before it is banned. Ezra, always a pleasure. Thanks for coming on.
Thanks, my friend. Thank you.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.